Thank you for joining me today. I'm really glad you're here. Irrevocable trusts are one of the most searched and most misunderstood estate planning tools. This webinar is designed to provide clarity before you make permanent legal decisions affecting assets, taxes, and long-term goals. This is not a one-size-fits-all solution session. It is a strategy-first conversation. So today, as you know, we're talking about irrevocable trust, one of the most searched estate planning tools and also one of the most misunderstood. I want to be very clear about my goal for this time. My goal today is not to convince you that you need an irrevocable trust. My goal is to give you clarity before you make permanent legal decisions that affect your assets, your taxes, and your long-term plans. This session is educational, so I'll be speaking in general terms, not giving individualized legal advice. But by the end of our time together, you should know whether an irrevocable trust is something you should explore further or something you should put a pause on entirely. If you walk away today realizing an irrevocable trust is not right for you, that's a successful outcome. If you walk away realizing it might be right for you, but only with proper coordination, that's also a successful outcome. One important thing to keep in mind throughout today's presentation is this. Estate planning tools should always follow goals, not the other way around. Okay, so why this topic matters. I see irrevocable trust come up constantly online, on social media, and in conversations with clients. Unfortunately, I also see the aftermath when they're misunderstood. Unlike many estate planning tools, irrevocable trusts are difficult or sometimes impossible or extremely costly to undo. That means mistakes tend to be permanent. And most of the problems I see don't come from bad intentions, they come from incomplete information. So, a little about what this session is and isn't. This session is educational, so I'll be speaking in general terms and using examples, but nothing today is individualized legal or tax advice. What I am giving you is a framework, a way to think about irrevocable trust so that you know the right questions to ask before committing to something permanent. So I'd like to start with a little bit of trust law basics, just so we have a good understanding and a good footing in trust law. So I actually use the irs.gov website because I feel like that is the most important when it comes to the tax implications of trust. So we'll go through what is a trust. A trust is an entity created and governed under the state law in which it was formed. A trust involves the creation of a fiduciary relationship between a grantor, a trustee, and a beneficiary for a stated purpose. A trust may be created by any one of the following methods. So the first is a declaration by the owner of property that the owner holds the property as trustee. The next is a transfer of property by the owner during the owner's lifetime to another person as trustee. A transfer of property by the owner by will or by other instrument taking effect upon the death of the owner in trust to another person as trustee. Or last, an exercise of a power of appointment to another person as trustee or an enforceable promise to create a trust. The grantor, also known as the trustor, settler, or creator, is the creator of the trust relationship and is generally the owner of the assets initially contributed to the trust. The grantor generally establishes in the trust instrument the terms and provisions of the trust relationship between the grantor, the trustee, and the beneficiary. These will usually include the following: the rights, duties, and powers of the trustee, distribution provisions, ability of the grantor to amend, modify, revoke, or terminate the trust agreement, the designation and selection of a trustee or successor trustees, and the designation of the state under which the terms and provisions of the trust agreement are to be governed. The trustee obtains legal title to the trust assets and is required to administer the trust on behalf of the beneficiaries according to the express terms and provisions of the trust agreement. A fiduciary is an individual or organization charged with the duty to act for the benefit of another. A trustee is a fiduciary. The beneficiaries are those entitled to receive benefits from the trust. So a simple trust is a term used in the Internal Revenue Code to define a trust that is not a grantor trust or required to be treated as a grantor trust, is required to distribute all income annually, and does not distribute the corpus of the trust or make charitable contribution. A complex trust is a trust that is not defined as a simple trust or a grantor trust under the Internal Revenue Code. And a grantor trust is a term used in the Internal Revenue Code to describe any trust over which the grantor or other owner retains the power to control or direct the trust's income or asset. If a grantor retains certain power over or benefits in a trust, the income of the trust will be taxed to the grantor rather than to the trust. So some of the examples of this would be if a grantor decides who receives the income or has the power to vote or to direct the vote of the stock held by a trust, or if they have the power to control the investment of the trust funds or the power to revoke the trust. All revocable trusts are, by definition, grantor trusts. An irrevocable trust can be treated as a grantor trust if any of the grantor trust definitions in the Internal Revenue Code are met. If a trust is a grantor trust, then the grantor is treated as the owner of the assets. The trust is disregarded as a separate tax entity, and all income is taxed to the grantor. A testamentary trust is created by a last will and testament, which begins its existence upon the death of the person making the will. When property is transferred from the descendant's estate, the person who died, testamentary trusts are generally simple or complex. A testamentary trust is irrevocable by definition, as it comes into being at the death of the grantor. A living person that creates a trust during their lifetime, that trust is called an inter vivos trust. It can be established as revocable or irrevocable. An inter vivos trust can be simple, complex, or a grantor trust, depending on the trust instrument, which brings us to irrevocable and revocable trust. An irrevocable trust is a trust which by its terms cannot be modified, amended, or revoked. For tax purposes, an irrevocable trust can be treated as simple, complex, or grantor trust, depending on the powers listed in the trust instrument. A revocable trust may be revoked and is considered a grantor trust. State law and the trust instrument establish whether a trust is revocable or irrevocable. If the trust instrument is silent on revocability, then most states consider the trust revocable. So, at its core, an irrevocable trust is a legal structure. You transfer assets out of your personal ownership and into a trust. Once that happens, the trust, not you, becomes the legal owner of those assets. With an irrevocable trust, you are intentionally giving up a degree of control in exchange for specific benefits. Those benefits might include tax planning opportunities, asset protection, or long-term care planning advantages. So, what an irrevocable trust really means is you generally cannot change or undo it. You are no longer the legal owner of the assets. The trust, not you, controls the distribution, and it requires intention. That word irrevocable matters. It generally means the trust cannot be easily changed or undone. This is very different from a revocable living trust, which you can amend, restate, or revoke during your lifetime. I want to emphasize something important here. Irrevocable does not mean bad. It means intentional. Yeah. Okay, bye. These trusts are designed for specific situations, and when they're used correctly, they can be very effective. Irrevocable does not mean reckless. It means deliberate. It means we are intentionally limiting flexibility in order to gain protection or efficiency somewhere else. The key question is whether that trade-off makes sense for you. So most people start their estate planning with revocable trusts. Revocable trusts offer flexibility, control, and ease of change. A revocable living trust is a legal arrangement created during your lifetime to hold and manage your assets, allowing you, the grantor, to control them, receive benefits, and change or terminate the trust anytime while you're competent, ensuring a private, probate-free transfer to your beneficiaries after your death. It can even serve as a plan for potential incapacity. Irrevocable trusts are usually layered in later when goals are clear and the planning horizon is longer. One is not better than the other. They simply serve different purposes. Now let's talk about when irrevocable trusts are commonly used. One of the most common uses is estate tax planning. Texas does not have a state estate tax, but federal estate taxes can still apply to higher net worth families. Irrevocable trusts can be used to remove assets from your taxable estate and, in some cases, lock in today's exemption amount. This type of planning must be coordinated carefully with tax professionals. Another common use is asset protection. Business owners, professionals, and individuals with higher liability exposure may use irrevocable trusts to protect assets from future creditors or lawsuits. One critical rule, and this is critical, is that asset protection planning must happen before there is a problem. Once a claim exists, it's usually too late. It does not work retroactively. Another common use is long-term care planning. This is where irrevocable trusts are sometimes used, and this type of planning requires time, precision, and careful coordination. And this is because of Medicaid look-back rules. This is not a last-minute solution. It's a proactive one. Finally, and I would say this is probably one of the most popular uses, irrevocable trusts are often used in business and legacy planning. It helps families pass ownership interests, preserve wealth, and protect assets across generations. This is where estate planning, tax strategy, and business planning truly intersect. Irrevocable trusts can help preserve family businesses, create continuity, and support long-term legacy goals. but only with proper coordination. So some common misconceptions. This misconception section is where I see the most problems. One common misconception is I can still control everything. In reality, control is intentionally limited. That limitation is what creates many of the benefits, but it's also what surprises people. Another misconception is that irrevocable trusts are only for the wealthy. In practice, strategy matters more than net worth. I've seen modest estates benefit from irrevocable trust planning, and I've seen large estates harmed by using these tools incorrectly. A third misconception is relying too heavily on social media or online advice. These platforms are great for awareness, but they rarely provide the full context of what's going on and in what circumstance you would be using this planning tool. Some of the most costly mistakes include creating irrevocable trusts too early, creating them too late, choosing the wrong trustee, and failing to coordinate the trust with tax planning. These misconceptions are where I see the most damage. Irrevocable trusts limit control by design. They are not just for the ultra wealthy, and they are rarely easy to unwind. An irrevocable trust done wrong is often worse than no trust at all. So, some examples of irrevocable trusts failing. Irrevocable trusts go wrong through common mistakes like failing to fund them, which means leaving assets outside of the trust, improper management by trustees, where trustees are treating it like personal property. And this can easily lead to IRS issues or beneficiary disputes, ignoring the tax implications, or failing to update for major life changes, such as divorce, or if you want to add new beneficiaries or take someone off. All of these can result in lost asset protection, probate, or unintended tax burdens. Some courts have found that grantors still had true ownership despite the trust being there, and this nullifies protections. So, some common examples, let's go through them. Failing to fund the trust. This results in there being an empty trust. The most critical error is creating the trust document, but not retitling assets like your property and your bank accounts into the trust name. This leaves them to go through probate anyway, which defeats the purpose. Another one is retaining control or the benefits. This leads to IRS scrutiny. Grantors who treat trust assets as their own, such as paying bills with trust assets, continuing to use the property the same way as they were before without actual permission from the trust, they can lose protection. Courts may rule that the trust is a legal fiction, allowing creditors like the IRS to claim the assets. This was actually seen in a case where a couple lost their trust property to a federal tax lien for one of those reasons. Another one, which is really important actually, is poor trustee selection. Naming a trustee who is not financially literate, is biased, or if they have conflicts, like naming co-trustees that have competing interests, this can easily lead to mismanagement or family feuds. Number 4 is ignoring life changes and failing to update your trust. Not updating your trust or any estate plan following major life events such as divorce or a birth or a death in the family can render the terms of your plan outdated or create unintended consequences. 5 is tax traps and abusive schemes. Some complex trusts can miss out on a second step up in basis at the second spouse's death. So it's really important that you get professionals to help when you're doing trust planning. Also, we've heard of some promoters selling non-compliant, abusive trusts that fail tax laws altogether. The next is asset protection failure. The grantor transfers assets but doesn't respect the trust integrity, meaning the assets are not truly protected from creditors. And the last is beneficiaries can be trapped. A trustee might deny reasonable requests, believing that they know best, and preventing beneficiaries from receiving needed distributions. We actually had this happen with a client of ours who fell ill with cancer, and her corporate trustee refused to give distributions for health treatments that she wanted. It was a very sad situation, but also could have potentially been avoided. So, choosing the right trustee is really important. So, one of the key takeaways here is an irrevocable trust requires strict adherence to legal formalities and professional guidance. DIY or poorly managed trusts often fail to deliver their intended benefits and can create significant problems. An irrevocable trust done wrong can create tax issues, family conflict, and long-term regret. The most common issue I see is lack of coordination. Legal decisions made without tax or long-term planning input. So let's move to something positive. Some success stories, best practices for drafting. So we always add to all trust documents, well, most of them when it's appropriate, something called trust protectors. This allows a trustee to appoint a trusted advisor, which is called a trust protector, or if it's more than one person, you can call it a trust committee, to adjust terms for changed circumstances, like adding or removing beneficiaries or changing fiduciaries or adjusting the trust based on a change in tax laws or fixing ambiguities or errors. This is super important. A power of appointment may be appropriate in some circumstances, such as giving a surviving spouse the ability to adjust distributions. For a troubled child, say you decide to give it to them outright at a certain age, but they're just not mature enough to handle that. And so, if you give that power of appointment, the surviving spouse can then choose to give the child trust distributions instead of giving them a lump sum outright. The power of decanting. This means transferring assets to a new, more favorable trust. Delaware is a really trust-friendly state, a business-friendly state, for example, or to gain better tax treatment, asset protection, or administrative flexibility. Strategic funding. This means carefully funding trusts, especially when involving spouses, to ensure proper legal status and asset protection. Clear, adaptable language is important. Designing the trust with provisions for future changes, like moving to a more favorable state or adding investment flexibility. And then if needed, successful court modification can also come in handy. Courts often approve modifying a trust if it serves the trust's main purpose. So, say it's for a beneficiary's unforeseen medical needs, like the example that I gave before for one of our clients. The success of an irrevocable trust hinges on expert planning to build in flexibility and address potential future issues, rather than rigid inflexibility, which often leads to problems. Okay, so I want to kind of zoom out for a moment from what we're talking about. And I want to emphasize that good planning rests on three pillars: legal structure, tax strategy, and long-term goals. I often describe this as a three-legged stool. If one leg is missing, the entire plan collapses. An irrevocable trust might solve a legal issue, but create a tax problem if it's not coordinated properly. Or it might create tax savings while limiting flexibility in ways that don't align with your family or business goals. So, before choosing any tool, the most important question to ask is, what problem am I actually trying to solve? Next, consider, what flexibility do I need in the future? And finally, how will this affect taxes today and later? Once that's clear, we can determine whether an irrevocable trust is the right solution or whether another approach makes more sense. So, who should consider an irrevocable trust? Let's bring everything together with this slide. An irrevocable trust may be appropriate if you have estate tax concerns, need asset protection well in advance, are planning long-term care early, or have a clear long-term vision supported by professional guidance. Irrevocable trusts work best when there is clarity, time, and coordination. On the other hand, an irrevocable trust is probably not appropriate if you need flexibility, if your goals are still evolving, or if you're uncomfortable with permanent trade offs. There is no prize for using the most complex tool. The right plan is the one you understand and can live with. Sometimes the best plan is the one that preserves flexibility. Estate planning is always state specific. Texas planning looks very different than planning in states with estate or inheritance taxes. This is important to remember, y'all. Okay, so failing to plan often means planning to fail. We've heard that before. So I have some trivia questions. And for anyone who gets the right answer, we'll send you a little gift. I base these questions based off people who may have benefited from an irrevocable trust or at the very least, some proficient planning. So I'm actually doing this PowerPoint and talking. So you'll have to actually say the answer if you know it. Okay, so the first one is the artist who died without a will. I'm going to describe the circumstances. If you know the answer, say it. If not, if no one says anything in like a minute, I'll just say what the answer is. So the first is the artist who died without a will. This artist died without a will, which means intestate, in 1973, which led to a complex years-long legal battle among his heirs to divide his vast fortune and art collection, resulting in a significant portion of his work going to the French state as payment for inheritance taxes. His lawyer noted that he avoided making a will due to superstition, viewing it as tempting fate. Yes, Ashley.
Is it Picasso?
Yes. Okay, let me write your name down. Got it, Ashley. We'll send you something. Okay, so Picasso never created a will, despite his immense wealth and large estate. His lawyer explained this was due to a fear of death, a common reason for avoiding estate planning. I hear that a lot. He left behind thousands of artworks, properties, cash, and bonds with a complicated family structure because he had multiple children from different mothers. And settling the estate took about 6 years and involved numerous lawyers with disputes among his children and other heirs. A large portion of his collection went to France to cover inheritance taxes, becoming a significant part of the French national collection. Okay, the next couple people are musicians. So, this famous singer died without a will or any formal estate plan in April 2016, leading to years of complex legal battles, disputes among his many potential heirs, his sister, and 5 half siblings, and millions in legal fees to determine who would inherit his vast fortune, a situation that could have been avoided with proper planning. Does anyone know who it is?
Elvis.
No, that was a good guess, though. Oh, who's okay? Let me see that.
Michael Jackson.
No, not Michael Jackson. Any other guesses? Okay.
Prince.
Who?
Prince.
Yeah. Okay, who said that?
Christopher.
Got it. Yeah, it was Prince. Okay. So Prince died without a will. Since he died without a will, Minnesota's state laws dictated who inherited the estate, which ended up being his sister, Tika Nelson, and his 5 half siblings. The absence of clear instructions resulted in years of probate court with numerous people claiming to be heirs, disputes over asset valuation, and significant costs. The estate was eventually settled in 2022 with a significant portion of the assets going to the heirs and management company Primary Wave after lengthy negotiations with the IRS and family members. The entire process cost millions in legal and administrative fees, highlighting the importance of estate planning even for the wealthy. Okay, this next singer handwrote her wishes. She initially died without a formal will, leading to an estate battle among her 4 sons. But 2 handwritten documents, which are called holographic wills, were later discovered in her home, one in a couch and one in a cabinet, which eventually led to a court ruling that the 2014 document was her true final wishes, despite them being unofficial and containing personal notes. It's not Whitney.
Aretha Franklin?
Yes. Okay. When Aretha Franklin passed away in 2018, court documents indicated she died intestate without a will. Under Michigan law, her estate would typically pass equally to her 4 sons, with the court appointing an executor. 2 handwritten documents, one from 2010 found in a locked cabinet, and one from 2014 was found under couch cushions. And they surfaced later. They weren't formal attorney prepared wills, but they were handwritten, which are called holographic wills. And they included details about her assets and who should inherit them. The 2 documents differed, causing conflict among her sons, leading to years of legal battles and significant legal fees. A jury ultimately determined that the 2014 document found in the couch represented her true wishes and was valid under Michigan law. Okay, the next musician died without a will in 1981, largely due to his Rastafarian beliefs, leading to protracted legal battles over his substantial estate under Jamaican intestacy laws, which divided assets between his wife and his 11 children and caused decades of disputes, even involving allegations of forged documents.
Bob Marley.
Yes, Bob Marley. Who said that?
Miss Jordan.
Okay, got it. Hi.
Hello.
Bob Marley died without a will in 1981, largely. Oh, okay, here, we already read that part. Religious convictions. Marley believed that creating a will was contrary to his Rastafarian faith, viewing lawyers and legal documents as tools of Babylon. His estate was distributed according to Jamaican law, giving his wife, Rita, a portion around 10% plus a life estate, and the remaining 45% to his 11 children. So we're assuming that that other part was taxes, but it's just my assumption. The lack of a will created a massive legal mess with disputes over royalties, likeness rights, and ownership of property continuing for decades. A major scandal involved his attorney and accountant convincing his wife to predate and sign documents to transfer control of assets, leading to fraud charges and further legal battles. I read somewhere that this was about $9 million that she tried to transfer to herself. The absence of clear instructions caused significant financial stress and conflict among his heirs. After years of litigation, the estate eventually consolidated under the House of Marley, managed by his family, preserving his brand, but only after extensive legal wrangling. His estate became a classic cautionary tale about the importance of estate planning, even for those with spiritual objections, to protect loved ones from future conflict. This next person is an actor. He did not die without a will. He actually had a valid will from 2003, but it hadn't been updated to include his daughter. This led to a complex situation where his parents and siblings inherited the estate, though they voluntarily gifted it all to his daughter. The will left everything to his parents and siblings because it was made before his daughter's birth in 2005. But his family did ensure that she received everything as he would have wanted. Does anyone have a guess? This person is Heath Ledger. Last question. This person was a billionaire. He died without a valid will, leading to one of the most famous and prolonged estate battles in history. With numerous claimants and over 30 years of legal fighting before his fortune was eventually distributed primarily among distant relatives and a medical institute. His death left his vast estate to be settled according to state and intestacy laws, resulting in chaos and a massive court case involving hundreds of potential heirs and forged wills like the famous Mormon will. Yes, Keith, it's Howard Hughes. Howard Hughes died in 1976 without a valid will, meaning he died intestate, and state law, not his wishes, determined distribution. He left behind billions in assets, but no clear instructions, creating an enormous legal void. Over 600 people claimed to be heirs, including a gas station attendant named Melvin Dumar, who presented a forged handwritten will. The dispute lasted over 34 years, involved complex probate proceedings across multiple states. Eventually, the estate was divided among 22 cousins, with the Howard Hughes Medical Institute receiving the majority, but not before millions were spent on legal fees. So these are just a few cautionary tales of people who died without planning. Next steps. If today raised questions, the next step is not signing a document, not creating a trust that's going to lock all your assets in. The next step is a coordinated conversation that looks at your legal, tax, and long-term goals together. Irrevocable trusts are powerful tools, but power without clarity creates risk. So I thank you all for being here. Thank you for taking the time to learn before you commit. If you'd like to continue the conversation and schedule a consultation, or if you have any questions about another legal area, such as tax planning, tax controversy, or intellectual property protection, please don't hesitate to reach out to us. You can reach out to me personally if you want at Alisha@HydeLegalGroup.com, or you can reach out to Sierra, our administrative assistant, at Sierra@HydeLegalGroup.com. But otherwise, it's really been a pleasure to see you all, and I thank you for joining the conversation.